Happy to be here again on this Tuesday afternoon with you. Have another great lineup today. I think today is particularly practical. We always try to provide very practical topics for all of you, but I think this one really does hit that note. So I will just launch right in with our agenda for you. Our first presenter is going to cover an area of litigation that you might not really think about, but it involves the ADA accessibility of your website. So we're seeing a lot of activity in that area. Then we'll move on to an I-9 topic. This is the third time that I've covered an I-9 topic in my tenure as host, but very important developments going on in this area right now. And something new that's actually goes into effect today, August 1st. So wanted to make sure we hit on that with Joanna Silver. We'll move then to Howard Miller, who's going to talk about support animals in the workplace, something that I know that I'm seeing with a number of my clients, definitely getting more and more common. And finally, ending things with Travis Talarico, who will talk about workplace harassment now that this idea of remote work doesn't seem to be going away, prevents a lot of new challenges for employers. So with that, I'm going to go back and introduce again Dan Pouts, who's a member in our Syracuse office, but I actually wanted to mention something that's a new development here at our firm, which is that we have opened a new Elmira office, an office down in Elmira, New York, where Dan is a native, and Dan is actually managing that office. And so I wanted to make sure that our audience here was aware of that. We probably have attendees from the Southern Tier, and so now we're in a better position to service you out of that office. And Dan, if you wanted to mention anything about that, go right ahead. But other than that, we're looking forward to hearing about this ADA website litigation.
Thank you, Kristen. Yeah, and thanks for inviting me back on the webinar. I assumed that I've been here in a couple months. I thought that the feedback must have been so negative that maybe my invitation got lost. But thanks for having it. It's great to be here. And yes, the Elmira office is very much up and running. We've had space there. This is the 2-month anniversary actually today. And as Kristen mentioned, we have a wonderful client base down there. I'm hoping to grow that more. So if you're in the Southern Tier, if you do business in the Southern Tier, then please feel free to reach out. And we now have expertise and boots on the ground down there. So without further ado, my topic today is ADA website litigation, which, as Kristen mentioned, many of us don't know about and haven't heard about until, unfortunately, we get named in a lawsuit. This type of litigation has been going on for the better part, almost 2 decades now. And to back up a little bit, most of us are familiar generally with the ADA, which of course is short for the Americans with Disabilities Act. The Americans with Disabilities Act was adopted in 1990. And basically it was a way to eradicate discrimination, both in the employment realm as well as places of public accommodation. And when we think of places of public accommodation, we think of restaurants, hotels, retail establishments, things like that. And essentially what Congress decided was that we needed a law to make sure that there was equal accessibility at these places for disabled and non-disabled individuals. And undoubtedly, the law was a huge success in terms of ensuring that accessibility because there were specific architectural standards that were implemented that businesses had to follow. For instance, a doorway has to be a certain amount of inches wide. A countertop can't be over a certain number of inches high. And so that law did a tremendous job of ensuring equal accessibility. Unfortunately, at the time that law was passed, none of us knew what the internet was going to be. And certainly none of us knew, and Congress didn't know, that within a couple of decades, the internet was going to be the primary means by which we not only communicate, but we obtain information and purchase goods and services. So around early 2000s, mid 2000s, a couple savvy plaintiffs attorneys, they began filing lawsuits on behalf of sight impaired individuals, claiming that their client or clients were being denied access to certain websites. And so, of course, the first issue became, well, what is a website? Is it a place of public accommodation? And that was an issue that was litigated for several years. But for purposes of today's discussion, suffice to say that there's overwhelming case law in New York, and as well as in the Second Circuit, in which New York is located, indicating that websites are, in fact, places of public accommodation and thus subject to Title III of the Americans with Disabilities Act. There is some case law elsewhere that you may read or you may hear about that says, well, unless the website has a corresponding brick and mortar location, if it's just a website alone, it can't be considered a place of public accommodation. Unfortunately, that's not the case in New York. So next issue to determine is, well, if we operate a website, are we a place of public accommodation? And essentially, if you are, the definition is extraordinarily broad. But if you're selling goods and services, or if you're engaged in any type of commercial activity at all, unless your website exists purely for educational purposes, chances are you are a place of public accommodation. So because of that, because we've determined that your website is a place of accommodation, you need to be compliant with Title III of the ADA. What does that mean? Well, that's a great question. And despite my best efforts, one that neither I nor any other attorney that you're going to speak to has a concrete answer. And the reason is because Congress, particularly the Department of Justice, has not promulgated any specific regulations. Unlike the brick and mortar architectural standards that we see in the Title III ADA cases for brick and mortar locations, in 2010, after these cases started, the Department of Justice said, yeah, no, we're going to get right on it. We're going to promulgate standards, we'll ex post haste, we're going to get right on it. Well, now it's, by my math, 13 years later, and we still haven't seen anything, nor do we really anticipate seeing any specific standards in the near future, only because we've now been through 3 different presidential administrations during that time, none of which really dug in on the issue. As a result of that void of specific regulations or guidance, there's been chaos, particularly over the last 5 years, but certainly going back a decade. And it's the uncertainty creates fertile ground for these websites to be filed. And there's a bunch of different plaintiffs' attorneys that have jumped into the marketplace. And I saw a statistic the other day that in the last 5 years alone, the number of these website related ADA cases has increased over 500%. So we're seeing these all the time. We're seeing them throughout different markets, throughout different geographic areas, colleges and universities, hotels, restaurants, retail establishments, online retailers. It runs the whole gamut. And a lot of times folks don't know that these types of websites or lawsuits exist until they've been sued. So a lot of this is on our end is educational. The main problem, as I see it from a defense standpoint, is there's really no defense to these cases. There's no specific defense. You can't point to a standard and say, hey, we're following this standard, ergo the case should be dismissed. Over the last several years, there's a worldwide web consortium, W3, and what they've promulgated and come out with is what's called, a lot of us have heard it in the context of, it's called WCAG is the acronym, but it means Web Content Accessibility Guidelines. And those are a series of guidelines that if a website follows, according to the World Wide Web Consortium, that website is compliant or accessible. And so there's been some courts, although not many, who have, in the context of a pre-answer motion to dismiss, have said, okay, if you're substantially compliant with the WCAG, with those guidelines, then in substantial compliance with those, then you're not in violation of the ADA, Title III of the ADA. The problem is, what does substantial compliance mean? What substantial compliance means to me may be different than what it means to you, and may be different than what it means to judges. So because of that, there's no real concrete defenses that can be raised, or very few concrete defenses that can be raised in opposition to this type of lawsuit. The other problem is that even if we were inclined to strap the helmet on and to go to battle on these cases, it's cost prohibitive, and it's cost prohibitive by design. What I mean by that is these plaintiffs' attorneys know they found a sweet spot somewhere between $10,000 and $20,000, where that's what they'll settle these cases for. And the reason that's important is they know that it's going to cost a defendant that much or more without any guarantee of success to bring a pre-answer motion and to fight it. So basically, you say the analysis is, well, I can pay, even if it's I think this is a nonsense case, I can pay $15,000 today, and I'm guaranteed the case will be dismissed, or I can pay my attorney, $15,000 or $20,000 without any guarantee of success. So there is an art in negotiating favorable resolutions in these, which thankfully we've been very adept at getting a lot of these resolved for what I would consider below market rate. But that's why you don't see a lot of case law on this, because we don't see a lot of defendants fighting it because it's cost prohibitive. So what can I do to get out in front of it? That's the question that I'm asked all the time. A couple of things. One is talk to your insurance broker. There are insurance policies. Oftentimes we see coverage come up in the context of EPLI coverage. CGL coverage typically doesn't cover it, but there's other types of coverage that you may, policies that you may find coverage under. So one thing is, when this ends today, you may want to call or send an email to your insurance broker and say, hey, I heard about these website accessibility cases. Am I covered for something like that? That gives you a little bit of comfort. But the only magic bullet, so to speak, is the website needs to be, as substantially compliant with these WCAG standards. That's about as good as you can do to guarantee or to increase your chances or decrease the likelihood that you'll be sued. And there are countless third-party vendors out there that'll provide these types of services. They'll come in, they'll run a diagnostic, they'll give you an idea of, okay, these are the major issues, these are the not so major issues, and here's the cost associated with implementing these changes. It can be cost prohibitive, believe me. And the one thing that we're seeing a lot of now that I would caution you strongly against is there are some vendors that they'll sell you what's called an overlay or a widget, which basically acts as a mirror of your website. If you click on an icon, it opens up a different window, and it's supposed to mirror the content on the real website, but in an accessible fashion. Suffice to say, there's been a ton of litigation on that, and there's plaintiffs' lawyers now that just go after websites that have these widgets or overlays, and it's not good for them. So I would discourage you or caution you against implementing a measure like that. But there are other things we can do. Certainly, I'm happy to walk you through it. We have other attorneys here at Bond that have experience in this realm. But for now, like I said before, most of this is educational. And not only in this realm, but others, a lot of times clients don't know what they don't know. So if this is something that you're concerned about, if you believe that you are, or your website is a place of public accommodation, please reach out to us. We could talk through it and hopefully find a good solution to what we have going on. So thank you again. And certainly my contact information was put up there. Call me, email me. I'll get right back to you.
Thank you very much, Dan. Appreciate it. And no, you were not taken off the list, but we appreciate you being back again. Okay, so next we're going to move from Syracuse down to our White Plains office, where we have one of our attorneys there, Joanna Silver, who is one of our immigration experts. You've seen other immigration experts here recently, but Joanna is going to provide us with details today about some very, very new developments. Thank you for joining us, Joanna.
Thanks, Kristen. Happy to be with everybody today. Today is August 1st, and none of us seem to know how that's even possible, that we're about halfway through the summer, maybe a little bit more at this point, but it is August 1st. And there's a couple new things happening today with the Immigration Service, and we wanted to bring those issues to your attention as soon as we possibly could. Next slide, Kathy. So first of all, there's a new Form I-9 available today, literally hot off the presses here. I wanted to include it in the slideshow this morning, but unfortunately, the Immigration Service printed it a little bit later than anticipated. So there's a new Form I-9. It's available today. The edition date is August 1st, 2023. Employers can use it now, but they absolutely must use it by November 1st, 2023. So essentially, if you're comfortable with the old form, you've got until November 1st to switch over to the new form. The form looks pretty good. I got to say, I've got it right in front of me. A couple of major changes is that sections 1 and 2 of the form are on one page. It's very organized. It's very efficient looking. The form is now fillable on tablets and mobile devices. So we're inching closer and closer, I think, to being completely electronic. The preparer, translator, certification, and re-verification and rehire sections are no longer on the form itself, but are supplements to the form to be used when necessary, which is also nice. If you remember, I think on the current form, I think there's a little section where you can re-verify employees when you need to re-verify their work authorization. On the re-verification supplement to this form, I think there's about 5 or 6 sections. So you really can use the form for your employees for a few years, probably, for those that need to be re-verified because their work authorization is renewed. And those are mostly people who are working for you on non-immigrant visas and other forms of work authorization that have an expiration date. There's also a revised list of acceptable documents that tells you which receipts are acceptable to use as Form I-9 documents, and also some guidance on the automatic extensions of work authorization. Those are some concepts that have worked their way into the Form I-9 arena recently, and myself, I would have to go and look up the guidance every time an employer had a question. This way, it'll be nice. It's right in front of your face. You will know whether or not you can accept a receipt that's presented by an employee as proof of work authorization or not. And the final item that occurred on this form is that the instructions are only 8 pages instead of 15, which I think is an improvement. But given that the form is now 1 page instead of 2 pages, I think the ratio there is still, 8 pages to 1 page. So I'm not so sure that's a great development. But in any way, for those of you who love the organization of Form I-9, new form available today. Go ahead and use it. If you have any questions, let us know. If you're comfortable with the current form, you've got to give it up by November 1st, 2023. Next slide, please, Kristen. So as Kristen mentioned, we've had a couple people present on this issue in the past on this webinar. We had some flexibilities during the COVID era that were provided by the Immigration Service, which made it easier for employers to inspect the identity and work authorization documents of employees who were working remotely over the last 3 years. And that flexibility, I'm not going to go into it right now because I know we've discussed it previously. And I list here a YouTube link where you can go and watch the prior presentation by my colleague, Ksenia Premo, where she talks about the flexibilities that were available. Those flexibilities were over yesterday, July 31st, 2023. And we are moving into the compliance stage of these flexibilities, where by August 30th, 2023, employers have to perform in-person physical inspections of identity and employment eligibility documents of those employees who were hired between March 20th, 2020 and July 31st, 2023, if those individuals' documents were inspected remotely using the COVID era Form I-9 flexibilities. So if you've got employees who you brought on and onboarded during the COVID era and had to use the flexibilities, which basically consisted of viewing documents by fax, over Zoom, by email, definitely not in-person inspection of documents, you've got to, if you haven't already done so, reach out to those employees and have them come in with their physical documents and have them inspected either by the employer themselves, human resources, or if you've got authorized representatives of the employer who complete this task on behalf of the employer. And once the employee comes in with their original documents, the Form I-9 has to be updated, and you must note on the form that you've completed the physical inspection of the documents and that you've done so on such and such a date. A lot of employers seem to be a little surprised by this compliance deadline, but in theory, under the COVID era flexibilities, once your people were back on site who were inspected remotely within 3 business days, that you were to do a physical inspection of their documents and update the Form I-9. So if you're behind, unfortunately, it's August. I know a lot of people are on vacation. But to the degree that you can, get moving on this and come into compliance best that you can, obviously, by August 30th, 2023. A couple things I just wanted to mention before we go on to the next slide is that there is an exception to this in-person inspection of documents that I'm going to talk about starting on the next slide, involving some new developments with respect to an alternative for procedure for doing inspection of identity and work authorization documents of employees. And the final thing I want to mention is with respect to the last bullet point on this slide, I often get the question whether the authorized representative of the employer who can assist with the inspection and completion of Form I-9 has to be a notary public. And I just want to say here, no, absolutely not. I think that's an issue that was out there when the form was developed in the late 1980s and 1990s, but the authorized representative can be anybody who has the ability to look at the documents, fill out Form I-9, sign it on behalf of the employer, and return it to the employer so they have that on file. And even though this individual completes the form and signs it on behalf of the employer, if there's anything incorrect on that form, it will be the employer who's on the hook for that. So make sure you pick your authorized representatives well, and obviously review everything that they do on behalf of the employer to make sure it's accurate and update as needed. Next slide, please. So here's the big news, I think, of this August 1st day. A few days ago, the Department of Homeland Security came out with a new rule setting forth an alternative procedure for completing Form I-9 that does not involve in-person inspection. And I think this is the first example that we're seeing from the Immigration Service creating an option and really kind of acknowledging the fact that we work differently now than we did possibly 3 years ago with respect to remote employment. So in fact, I think there's a client alert that just came out shortly on this topic from us, or emailed to you if you're part of our mailing lists, because this item is effective August 1st as well. The alternative procedure, which I'll get to on the next slide, not every employer can take advantage of this alternative procedure for completing Form I-9 without in-person inspection. In order to take advantage of this alternative procedure for remotely examining identity and work authorization documents, the employer has to be a qualified E-Verify employer. And I've listed the definition here as to what that means. Essentially, you've got to be in good standing with E-Verify through the government. You've got to be enrolled in E-Verify with respect to all hiring sites that are going to possibly use this alternative procedure. The employer has to comply with all of the E-Verify requirements. And at the bottom here, what I wanted to mention, previously I discussed having to do in-person inspection and of documents for those who were inspected remotely during COVID era flexibilities. And I mentioned that has to occur in person before August 30th, 2023. There's a little gift here for E-Verify employers, which allows E-Verify employers who meet the definition of qualified E-Verify employers to use this alternative procedure in order to come into compliance by August 30th, 2023. So instead of having to do an in-person inspection of the individual and their physical documents by August 30th, those who are in E-Verify, enrolled in E-Verify, will be able to use this alternative procedure instead. So without further delay, next slide, let's get to what this alternative procedure consists of. So if you are an E-Verify employer and meet the definition that I posed on the prior screen, within 3 business days of an employee's first day of employment, what you're going to do as the employer is you're going to examine copies of the employee's Form I-9 documents provided by them. You're going to look at the front and the back, just as you did if you did any remote inspection during the COVID era, and decide whether or not they reasonably appear to be genuine. Then you're going to conduct a live video interaction with the employee, which I think is a fancy way of saying Zoom or Teams meeting, to be sure that the documents that you have reviewed the copies of are related to the individual. So you're looking at the driver's license, and then you're looking at the person on the screen to determine whether that is who they say they are. And during this meeting, the employee is going to present their actual documents. So you will have to look at their actual documents on the screen, the copies that you have in hand, and determine that they match 100%. Then what you're going to do is you're going to complete on the new Form I-9, which actually has a new spot, which I would show you if I could, but there is a box where you check if you used the alternative procedure to examine the documents and use the alternative procedure to complete section 2 of the form, or the re-verification supplement if you're re-verifying an employee whose work authorization has since expired. With this process, you're going to retain clear copies of the documents front and back. And I just wanted to note here, for those of you who are enrolled in E-Verify, the requirement has always been that you have to retain copies of the List A documents for Form I-9. But with this new alternative procedure, you have to make copies of the front and the back of the documents that are used to verify the individual. And then you proceed and you create the E-Verify case for the new hire. So it's very similar and very practical and logical. So it's nice to see the Immigration Service moving in a direction where they're making this process a little bit more real world, relatable for the employers. Next slide, please, Kathy. So here are some odds and ends just to keep in mind as you digest all of this information. The most important thing is that this alternative procedure, again, effective today, it's optional. It's not required. And so just keep that in mind. There's nothing E-Verify, there's nothing requiring you to start using this, but it is there for you if you want to use it as employers. If you do offer it to new employees at a hiring site, you've got to do so consistently for all employees at that site. That is a rule just to avoid any appearance of possible discrimination. Employers can also choose to just use this alternative procedure for remote employees and continue to do physical inspection for on-site or hybrid employees. And you must allow employees who are unable or unwilling to submit documents using the alternative procedure to submit documents for physical inspection. So the important thing is employers don't have to use it. E-Verify employers are the only employers at this point who are eligible to use it, which might give some of you who are listening today, if you aren't already enrolled in E-Verify, your companies might want to start thinking about that. As a reminder, New York State does not require employers to enroll in E-Verify. I don't think that New York State would ever require such an enrollment in E-Verify. So there is a lot of issues to consider before you just say, I want to do remote inspection. I'm signing up for E-Verify today. Make sure, that you take the proper channels within your organization to discuss what that means, the obligations that employers will face as a result of enrolling in E-Verify to take advantage of this new alternative procedure. So a lot of questions, a lot of new things on the first day of August, right when everybody's trying to chill out for the rest of the summer. The Immigration Service decided to give you some things to do here. So I'm sure there'll be a lot of questions going forward. And, if we don't get to them a lot today, we certainly are available to help you guys as you transition through these different developments with respect to Form I-9 and the inspection of individuals and work authorization documents.
Great. Thank you so much, Joanna. There are a lot of questions. A number of you asked for a link to the form, and so I put it in the Q&A several times, but the other questions I'm going to have to leave for Joanna. Okay, so moving on to our next presenter, Howard Miller down in our Garden City office. We'll talk about support animals in the workplace. Go right ahead.
Thank you. So thank you all for tuning in. So I happen to be one of those law geeks that find it necessary to review on a daily basis all the periodicals about all of the recent cases coming down. I am in treatment for this condition, but so far I have not been cured. And I happened to come across a case a couple of weeks back about service dogs, and I thought it would make a good blog article. And if those of you who are interested, the article is available on our website. Now, we happen to have a dog that comes into our office here on Long Island pretty much every day. For those of you who have had occasion to visit Long Island, you will know that after you have spent some time on the Long Island Expressway, you are likely in dire need of an emotional support dog to help you through that. Now, as we have seen, the requests for service animals and support dogs and have become very prevalent. And there have been some high-profile cases where things have perhaps gone a little too far in terms of requests. Some of you may have seen an article about a patron of McDonald's in Wisconsin who actually tried to bring her support kangaroo into the restaurant. Well, when I read that story, I have to confess, the thing that really jumped out at me was not whether that would be an accommodation you'd have to give, but was, how does one get a kangaroo in Wisconsin? Is that something you can order on Amazon? Like, how does that come about? Other requests have been a little unusual. You've heard people trying to bring on an airplane things like iguanas or snakes. I even heard a story about a gentleman claiming that he needed an emotional support alligator. Now, I don't mean to sound very judgmental, but I think if you're in need of an emotional support alligator, there are probably more profound accommodations that we're going to need to discuss with you. That just seems a little strange. But going back to what we see more often and what we're seeing more on a daily basis is a request to bring dogs into the workplace. And federal law is different than state law on this topic. So under the federal law, they really only talk about service dogs versus an untrained emotional support animal. And what makes the difference is that a service animal is actually trained to do a specific thing. So it could be what we talk about with guide dogs, or a dog that can tell when the owner is going to have a seizure or is in need of their medication. There also can be dogs that are specially trained to help people with post-traumatic stress disorder, but they serve a particular purpose as opposed to a generic, I just want to bring a dog for emotional support. But New York has expansive definitions and really doesn't distinguish between the two of those. So what we suggest is that when someone comes in and says, I want to bring my dog into work. So let's say just on the back of my wall here is a picture of my COVID rescue dog, Bella. And let's say I work for you and I come to you and I say, I'm experiencing a lot of anxiety. I want to bring Bella to work with me. Do you have to automatically grant that accommodation? Some commentators are saying we're almost to that point in New York. I still think we can take a pause and ask first for, do you really have a disability that requires an accommodation? So I think we could ask for a medical note that someone is suffering from an anxiety disorder. Also that they would actually need this dog as opposed to some other accommodation that we could give to help resolve the problem. I think, though, also another factor that comes in when we talk about accommodations is there an undue hardship in granting the accommodations? I think it's only going to be in the most narrow circumstances that we're going to be able to say that bringing a dog into the workplace is going to be an undue hardship. So I think when these requests come in, I would not automatically be rejecting them. If you think that this is not bona fide, I would suggest that you call counsel and we help you go about teasing this out to make sure that this request is legitimate. So let's say we do decide we're going to allow the dog to come in. We can have reasonable rules about how the dog is kept. Now, in our office, we allow the dog, whose name is Harley, to come wander around the halls and come see us and stop in our offices and all that. But that may be a distraction in other workplaces where you may be able to say to the person, look, if you're going to bring your dog to work, it's going to have to stay in your office. You're going to have to walk it at reasonable times. It's going to have to be housebroken, and it can't be destructive. So, for example, going back to my own dog, I don't know if you're going to be able to see this, but this is what Bella has done to my Von Schoeneck King appointment book. So we kind of frown on that in terms of what happens to these things. So it would be hard for me to bring Bella here if she was going to do that to other people's work, if she was going to run around the office, eat people's PowerPoint slides or briefs that have to be filed shortly. So I think while this is becoming more and more prevalent, we're going to have to grant more of these. It's still not entirely the wild, wild west out there. And I would suggest that you call counsel as these things come to pass.
Thanks, Howard. Always entertaining. Appreciate that about you. Can I put you on the spot? I mean, I think a common question we get is about allergies, and about several people asked that in the Q&A here today.
Yeah.
Is that an undue hardship?
It's been found that it isn't. I suppose where the guidance talks about an exceptional situation where a dog comes to a school and you have a lot of allergic kids in one space, maybe that would be, but the fact that one person has an allergy, they say that that's not going to be enough to say it's an undue hardship. So I would imagine a situation, again, looking at the layout of our office, let's say we did have somebody who was allergic to dogs. I think we would probably keep the dog at one end of the office space, and again, not allow the dog to wander, and the person with the allergy somewhere else. So we could accommodate it without it being an undue hardship.
Yeah, and I think you made a good point that, you analyze it like a reasonable accommodation, which means you don't automatically jump to that requested accommodation. You go through and you say, okay, is there something else that could assist you with that accommodation? And I know we've done that in some workplaces. So, and
we've seen it with our public school clients where some children have had service dogs, and there have been complaints, about allergies, and those complaints have not barred the service dog from coming in.
Yep. Well, thank you so much. I do think we're more and more and more. So, all right, our last topic today, going back upstate to Rochester, where Travis Tallarico is an associate in our labor department. And I asked him to talk today about some specific concerns with workplace harassment in the age of remote work. And I wanted to make a mention here that many of you might be familiar with Bond's online sexual harassment training that we offer. The interactive product that's compliant with the state regulation. And we're in the process of refreshing it. And its release of the new version is imminent. And I know that we added examples in that training where you're talking about a remote situation. So if you are a user of that training, or maybe you'd like to be in the future, that this is a topic that will be covered in that training. But with that, I wanted to pass it over to Travis.
Thank you very much, Kristen. Hi, everyone. Nice to be back on again. I know I've got only about 5 minutes left in our blocked out time here, so I'll try to make this as short and sweet as possible. Bear with me if we go a couple minutes over. But if we want to hop to the first slide, so basically, in context of this discussion, going to lay out a few things that I think are a bit of a prerequisite as to why this may be a bit more of a area of concern moving forward, and what might be a relatively unique area of litigation, which has not been explored all that much to this point in time. Again, given with what's a fact now is that remote work is becoming very common for many companies, and it's not going away anytime soon or ever, as Kristen alluded to. So the prerequisite of this, what might lead to an uptick in these potential types of claims and the substantiation of these types of claims, is everyone on this call is likely aware back in April, the New York State Department of Labor had rolled out a revised sexual harassment policy to update the prior one from 2018. And for the purposes of this presentation, the revised policy places an emphasis that sexual harassment and other forms of harassment and discrimination can occur while employees are working remotely, such as through virtual meeting platforms like Zoom, Teams, messaging apps, and also after working hours between personal cell phones. And the new model policy also emphasizes New York State standard to establish a prima facie case of sexual harassment, which is any harassing behavior that rises above petty slights and trivial inconveniences, which is a lower standard than the severe and pervasive standard, which is a requisite standard under federal law. And the New York standard is further analyzed from the standpoint of, and this could be in quotation marks, but a reasonable victim of discrimination with the same protected characteristics. Additionally, and as Kristen somewhat alluded to in terms of the revisions that we're going to be doing to our sexual harassment training materials, New York State's updated training materials that was released alongside of the new model policy now also includes references and hypotheticals related to remote harassment. So to provide kind of some prior context to this, the concept of remote harassment or harassment outside of the workplace by no means is necessarily new. But generally speaking, it can be difficult for a plaintiff, at least under federal law and what used to be New York State standard as until a few years ago, to establish a prima facie claim under the severe and pervasive standard, usually when there's none of the harassing behavior that is actually done face-to-face or in the physical work site. However, it wouldn't be necessarily surprising, at least under New York State law, to start seeing both an uptick of claims, of harassment claims, where there is no actual physical face-to-face interaction, and particularly given the relatively easy standard it is to at least assert a potentially viable claim of New York State law. So, to provide some examples of this, there is now a situation where a viable case of harassment or discrimination could occur theoretically between two employees who have never met in person before, might not live within the same state, where their only interactions are, might be through a computer screen or even less than that, just be it messaging. So if we go to the next slide, we'll be discussing kind of some practical implications of what might be making sense to be doing moving forward and what might be coming down the pike with these types of claims. So some suggestions would be ensuring to be updating all sexual harassment, general harassment, and discrimination trainings, and taking note of the revised training materials that New York State has provided, which now include hypothetical scenarios that relate specifically to remote work or virtual harassment, if we want to call it that. Increasing education for supervisors and employees on what can possibly constitute harassment. And to some extent, potentially, this really opens up an avenue where employers really might not be able to have much, if any, control over the harassing behavior. And just a couple examples of that would be the potential for the behavior to occur outside of standard working or office hours, or physically outside of the workplace. And from what I think a lot of us have seen, especially over the last few years, particularly over those of us that use social media, how it might be easier to harass somebody or engage in type of behavior that a person might not necessarily do if you were sane or interacting with somebody face to face. But to be able to do that from the call it the shield of a computer screen or a keyboard. And so just to wrap up, so what some best practices might be moving forward with these types of claims, if and when they do arise, are ensuring harassment and discrimination trainings are up to date, revising handbooks and other policies as needed, ensuring that proper channels are in place to report all forms of harassment, and specifically placing an emphasis on, what might be this, call it new style of harassment, encouraging employees to report any harassing behavior through any medium, in person, virtual, or otherwise, and to remind employees that no harassing behavior will be tolerated in any way, shape, or form. So as always, if any scenarios that arise that might be of concern, or if anyone has any further questions, obviously reach out to me or anyone else here at Bond who you're regularly in contact with.
Thank you very much, Travis. So that brings us to a close once again today. Appreciate everyone tuning in, listening. We will be back here again next Tuesday at noon with Gabe, and then I'll be back the week after that. So thanks so much for listening, for tuning in, and we will see you soon. Take care.